Public Education and First Generation Initiatives is now called to order. Today is Monday, December 7, 2015, and the time is 3:36 p.m. What we have in our agenda is Bill number 20933, which was introduced by Speaker J.T. Wanpat, Ed.D. It is an act to amend Exhibit 1 of Public Law 32-236 relative to the rules and regulations governing the standards of professional conduct for Guam Educators. Notices for this public hearing were disseminated via email to all centers and all main media broadcasting outlets on November 30th, 2015 to meet their 5-day notice, and on December 3rd, 2015 for the 48-hour notice, and in print media on December 4th. I would like to thank my colleagues, and of course to my left is Speaker Judy Wanpat, who is the sponsor of the bill, and then to my right is Vice Speaker B.J. Cruz for their attendance. And I would like to now turn this over to Speaker Judy Wanpat, who can speak about the bill before we start the testimonies.
Thank you very much, Madam Chair. What I'd like to... Is there any... Are those on? Okay, I think maybe that's it. Two were on at the same time. Yeah, I turned it on. Okay. So what I'd like to do is to share with you some of the history behind these rules and regulations that's relative to governing the standards of professional conduct for Guam educators, which brought all of you to here today. In 2007, Governor Felix Camacho sent Bill 99 to the Guam legislature to create the Guam Commission for Educator Certification to provide professional educator certification. The intent was to establish the commission separate from the Guam Department of Education to ensure that the education of our children is performed by professionals who have met sufficient standards and qualifications. So segregating the commission from GDOE would provide a strengthened sense of identity to the commission and its duties. It would also allow the commission to focus solely on certification issues and highly effective teaching. Bill 99 designed the commission to be comprised of professional members of the community who would best be able to develop objective and appropriate standards, evaluation measures, and procedures. Bill 99 also mandated that 3 of the 7 commission members be current public school employees, a teacher, a counselor, and 2 administrators, to ensure that the concerns of educators would be heard and considered in the work of the commission. So the purpose of the commission, according to Bill 99, is to certify and license qualified education professionals. The commission also was given the authority to determine if improper conduct by the certificate holder was sufficient to warrant suspension or revocation of the certificate. The commission was thus given the power to adopt rules for its purposes, including rules that provide for disciplinary proceedings, including the suspension or revocation of an educator certificate. So on May 9, 2008, Governor Camacho signed Bill 99 into law, which became Public Law 29-73. In August 2012, the Commission drafted rules governing the Code of Ethics for Guam educators to address the Commission's role in dealing with suspension and revocation of educator certificates. They held various meetings discussing these rules, which were announced in the newspaper, and they submitted the rules to the Attorney General's office for review. They held a public hearing on August 7, 2014, which the superintendent sent an email to all teachers announcing that the commission will be holding a hearing. A commission member also had attended a meeting with some union individuals, and I understand even the vice president was there and informed them that, and had announced the public hearing. On October 14, 2014, the commission officially adopted the rules and regulations relative to governing the standards of professional conduct for Guam educators. On October 20, 2014, the rules were officially transmitted to the legislature by the governor. As the former chairperson of the Committee on Education, then I introduced Bill 420-32 to approve the rules on November 12, 2014, because the Guam Legislature must by law approve, disapprove, or amend any rules within 90 days of their filing. I held a public hearing on November 24th, 2014, and after consulting with the Commission, the bill was amended based on recommendations and concerns expressed at the hearing by both teachers and GFT representatives. My staff met with a representative from the union and shared the amended bill. On December 17, 2014, the bill was passed by the 32nd Guam Legislature and became law on January 16, 2015, as Public Law 32-236. On March 16, 2015, Senator Underwood held an informational hearing on Public Law 32-236. Present at the hearing were the Executive Director and members of the Guam Commission for Educator Certification. Unfortunately, they were advised by the Governor's Office that they should not testify because of the pending lawsuit. They listened to the suggested amendments made by those who testified before the committee. They transmitted to my office the proposed amendment to the Ethics Code that they felt were appropriate. Thus, Bill 209-33 contained most of the recommended amendments made during the informational hearing. I must point out that the members of the Commission were comprised of stakeholders of public education, and I believe that they're capable to govern the certification process from issuing to revoking a teacher certificate. Thank you, Madam Chair.
Thank you, Speaker Wonka. So we have a number of people. I think 10 people wanted to have signed up to testify. So let's start. I'm just going to go down the line. So we have Mr. Pete Adams, Superintendent John Fernandez, Lisa Barbara Cruz, Leah Santos, and I have here Dr. Gail Hendricks, who's assigned to do it. Were you going to?
Thank you, Senator, Chairman of the Education Committee, Speaker Wampat, and Senator B.J. Cruz. Good afternoon. I had prepared a written testimony, but then as I was coming down the hill, I said, you better stop that long writing and get straight to the point, so I'll do it orally. Thank you for this opportunity to give us to make comments on Bill number 209. I'll make it straight to the point. We need to treat teachers as professionals, as they are professionals. Should there ever be a case that may be in question, there is a procedure to follow, and that is from the principal to the deputy superintendent to the superintendent to the board, and if they're still not satisfied, they can go to civil service, and if they're still not satisfied, they can go through the judicial process. And I think, quite frankly speaking, senators and Madam Speaker, this is the correct procedure to follow. And I ask you to please carefully look this over. When I first, several months ago, when I first came across this legislation, it bothered me. And I'm glad that it resurrected so that we can fix it and treat these teachers as professionals. I'd like to get off this chair and allow, because I'm pretty sure that many of these people that are here have a lot to say, and they are the stakeholders. They're the ones affected. But I also have our superintendent here, so please allow me to step aside and let the rest of these people speak, okay? Thank you, and good evening. Happy holidays to all of you.
Thank you, Mr. Adda, and Merry Christmas to you. Mr. Superintendent?
Holiday, you should have a copy of my statement. Actually, it's only going to be the cover page. Underneath it is actually just a copy of the prior testimony that I provided for you back in March. So I'll just read. As earlier this year, we provided input on Public Law 32-236, which approves standards of professional conduct for educators on Guam. In that testimony, the copy attached, I reiterated the department's commitment to ensuring that educators are not only qualified and certified to teach in our classrooms, but that they maintain a high standard of professional conduct, given the trust placed in them to care for and educate our children. And that commitment remains intact. At the same time, I did raise concerns that were identified by employees regarding the new law and its implementation. The input was categorized as follows. Number 1, procedural issues. Number 2, questions about scope of requirements. And 3, equity and fairness concerns. So based on those categories, DOE made specific recommendations to improve the law. Based on our review of the proposed bill, I want to thank the committee for addressing the majority of those issues and suggestions raised in our prior testimony. At this point, we would like to hear from other stakeholders regarding any continued concerns and ask for additional time to see if there are any areas in need of further clarification. So I think when I ask for additional time, I'm just, whatever time you are allowing to complete the gathering of testimony, what I would want to use that time for is just to do any more of the technical clarifications and adjustments that will often come with this type of legislation. So, for instance, we do see a potential conflict between sections 2 and 13 of the proposed bill, which sets forth time frames for filing complaints and filing required reports. But those are issues, I think it's just a matter of clarifying the intent and getting the right language in there. So if we could be afforded the additional time to clarify these and other similar issues, it would be appreciated, and we will forward you additional comments in writing after this hearing. So thank you again for the opportunity to testify. If you look at the testimony that we sent earlier, it was pretty thorough, and again, as I was going through it, it looked like most of those have been addressed directly in the bill that is before us. So, I think the only thing that remains, as you know, we have a number of employees who deal with these processes and matters on a day-to-day basis. So I said, let me just offer them an opportunity to make any suggested minor adjustments because I think most of the content has already been addressed. If there's anything else that comes up here that we need to address in partnership with you, we're happy to lend our support for that. Thank you.
Thank you very much, Mr. Superintendent. Okay, we have, just one moment, Lisa. Yes, we have Ms. Lisa Baza-Cruz.
Hafidang, good afternoon. Honorable Speaker Wonpat, Vice Speaker Cruz, and Madam Chair, Senator Underwood. My name is Lisa Baza-Cruz, and I currently serve as the Vice Chairperson for the Guam Commission for Educator Certification. Please note that I have not presented this testimony to Commission members for their input or approval. Therefore, I am speaking as a private citizen. I wish to submit testimony in favor of Bill number 20933. I would like to begin with certain revisions that I found in terms of language. Did you want me to state those? Okay. If you begin on page 1, line 11, the sentence reads, begins on line 9. The fees for such attendance shall be the same as the fees of witnesses before the Superior Court, except that if the witness is. So I just changed that to read, with the exception of a witness who is a government employee. I continue again, page 1, line 12, where it reads, the subpoena shall issue in the name of. Again, I changed that to the subpoena shall be issued in the name of the Guam Commission. And on page 2, line 2, it reads, the court may compel the attendance of such persons or persons. So it should be of such person or persons before the commission. So those are those corrections. Public Law 32236 provides GCEC with the ability to sanction, reprimand, suspend, or revoke a certificate that it has issued. This component to GCEC's purview regarding maintaining certification is critical to ensuring the health of the profession and the safety of our students. I believe this bill speaks to the concerns of individuals and organizations that provided testimony during the informational hearing held on March 16, 2015. In doing so, I appreciate the well thought out and sound changes that address certain concerns. For example, the list that guides Section 3 certainly provides for better understanding of moral conduct. As educators, parents, and members of the island community, the safety and welfare of our students is paramount. This bill enhances the integrity of our profession. Thank you for the opportunity to provide testimony in support of this bill.
Thank you, Ms. Baza Cruz. Okay, and we now have Leah Santos. Thank you.
First, I'll read the testimony of Gail Hendricks, Chairperson, GCEC on Bill 209, presented on December 7, in writing and to be read in the record by the Executive Director of GCEC. Senator Wampat, Senator Underwood, Vice Speaker Cruz, thank you for the opportunity to provide input on Bill 209. First, let me apologize that I could not be present tonight as I have a class and this is the final week of the fall semester. My testimony is in favor of the proposed changes as written. My testimony will address concerns that I have been presented with and my concern for the health and safety of the students who have served by educators holding GCEC certificates. Throughout, I will refer to the children we serve as students because we do have a few adults and the term children does not apply. However, all are children in relation to the educators who work with them. It is longer than any testimony I've ever submitted, but I feel I need to address each issue, so I hope those not present will not stop after page 1. I also want to point out that I currently hold a valid GCEC certificate for teaching and one for school administration, so this law applies to me personally and professionally. What has gotten lost in all of the rhetoric is the fact that 98% of our certificated educators do their jobs to the best of their ability and with little fanfare or recognition. This 98% will not be personally affected by the fact that there is an ethics law. Fortunately, it is the 2% that need to be weeded out for the sake of our students and the school system. When I was first confirmed as a member of GCEC, I found that there was a section of Public Law 29-73 creating the commission that had not been completed. That was a code of ethics and appropriate measures in place to ensure only those who uphold the code remain in our schools. The work has been completed prior to my membership and was extensive and thorough. Members had reviewed existing Guam law, federal law, and existing laws from different states. While the law was still in draft form, it was apparent that every effort was being made to take the best from all of those existing laws and craft a document that will protect the integrity of the education profession on Guam and protect our students. In addition to reviewing the work thus far, I began my research by attending the Professional Institute sponsored by the National Association of State Directors of Teacher Education and Certification, NASDAQ, held annually, which address issues of educator misconduct they are facing in regards to the health and safety of students in the different school districts throughout the nation. I realized early on that many of the issues they face have occurred on Guam. It was hearing these issues and the effects of this behavior have had on the victims that the reality of the situation became clearer in my mind. We think of what is best for the adults, but what about the victims? We have a responsibility as educators to protect our students from the harm that can occur due to educators who willfully take advantage of their positions or choose to break the law outside of the school setting. And isn't that one of the primary responsibilities of educators, to protect our students? Is it not enough to teach content It is not enough to teach content, but to ensure our students feel safe so they can learn. I cannot get out of my mind one session I attended at Rhode Island NASDAQ conference, which included a videotape of an interview conducted to determine what happened. The boy was 6 at the time of the molestation and interview. The presenter explained that the boy was 11 at the time of the conference, and it was reported that prior to the incident, he was a bright, well-adjusted, happy young man, but since the incident he had become withdrawn, unable to function in the classroom, unable to control his bowels, and always afraid. Why are we not more concerned about the victims of these unsolicited, unwanted behaviors perpetrated on students? As educators, we should want these individuals away from students at the earliest possible time. Just this past Friday, a roundtable was held concerning school safety, which indicates a concern on Guam that does exist. There is no one sitting in this room that does not know of a situation where a student was taken advantage of, or the conduct of an educator charged with supervision was so egregious that it had the potential effect of putting students in danger. Yet we all know nothing was done for a variety of reasons, and these individuals continued to work in the system or left until the heat died down. The GDOE superintendent himself sat at the last hearing and testified that if employees resigned from any investigation would be terminated. What that means is that the employee lives in good standing and is eligible for rehire. Nothing can be done past the past behavior 60 days rule. That means the commission becomes the only recourse to keep those certificated individuals who do not belong in our schools from potentially continuing as if nothing happened or from being rehired. And it is rare that a family will file charges because of the embarrassment to the family. These responses are examples of why waiting for convictions most likely will not happen. Has this happened? Yes. After hearing the concerns of the GFT and the GDOE superintendent, the commission went back, sat down, and reviewed the concerns. Where the commission felt there was legitimate need for clarification or change, the commission made such recommendations to the originally substituted bill. Could the commission in good faith accept all recommendations? The answer was no. The argument that GDOE teachers should go through the Civil Service Commission is, in my mind, the wrong avenue for several reasons. First, the GCEC is not an employer, which is the purpose of the CSC to ensure personal rules and regulations have not been violated. Second, the removal of a certificate does not prevent a teacher from being hired elsewhere on the island. Most private schools do not require a certificate. It does not even prevent DOE from continuing employment as that is at the discretion of the superintendent. Third, I have been told of cases before CSC are already scheduled for 2017. As our students to continue to be victims while waiting for CSC to hear their case? I have two other concerns with the GCEC process being required to go through the CSC. First, are we going to change the requirements for all others licensure or certificated government of Guam personnel to also require any removal of licensure or certificate to go through CSC? Or will teachers be a special class of government employees? Secondly, and along the same lines, will DOE teachers have a special set of rules for them while all others who require a Guam Educator certificate will have a different set of requirements? Is this not a form of discrimination? One of the areas that has been of great concern is the consumption of alcohol. What I heard through the different testimonies was that the Commission wanted to prohibit educators from having a drink off duty. The Commission's concern in this area was not to prohibit educators from drinking within moderation, but to address drinking at school and at school events. Does it happen? Unfortunately, yes. Again, this is a safety issue. But more so, individuals who must have their alcohol during restricted times need help, not shielding from disciplinary actions. In this discussion of this issue, it has become clear that people do not understand that what the Commission wants is safe schools. If an individual gets the help they need and return as a productive educators, then by all means return return their certificate. I do want to point out that for GCA Section 4203 states that there's a prohibition for habitual intoxicant, which states, and I quote, "No person habitually using intoxicating beverages in excess or narcotic or other mind-altering drugs which are being used unlawfully shall be appointed to or retained in any office, appointment, or employment to the government," unquote. By the mere fact that this law exists indicates past legislatures considered this issue as needed to be formally addressed. Also, I fully support Section 24, which places the investigative jurisdiction on an external entity. However, I remind the senators that this will increase the Commission's budgetary needs. While in all honesty, I do not see that there will be a flood of complaints that will need to be investigated, I am sure there will be a few. I would also like to point out that the existing law has been in effect for almost a year, and the Commission has not received one formal complaint. The idea expressed that there will be a flood of get-even complaints has not materialized, and I don't believe they will. When John Grant, an investigator for the state of Georgia, came to Guam to provide training on the ethics issue, he made a statement, and I quote, "Guam's ethics code and penalties are very lenient," unquote. And yet there are those who think the law is too harsh. Educators have always been held to a higher standards, and rightfully so. We are charged with the education and safety of the students we work with, and their responsibility cannot be taken lightly. In closing, I thank you for the opportunity to provide testimony on Bill 209, which I fully support, again as currently written. Gail Hendricks, EDD, Chairperson, Guam Commission for Educators Certification. Senator Underwood, Speaker, and Vice Speaker Cruz. I'm Leah Santos, the Executive Director of GCEC. The Guam Commission for Educators Certification wholeheartedly supports Bill 209-33. Many of the recommended changes were based on the March 16 informational hearing discussions. In addition, the bill strengthens the definition for immoral conduct by citing existing statutes and through additional provisions. We would like to recommend the following technical changes. Page 1, lines 11 to 12. Quote, "A government employee, comma, no witness fee shall be given. The subpoena shall be issued in the name." Okay. Page 2, line 11, add a comma after government employees, comma, no witness. Page 1, line 22, quote, "The subpoena shall be issued," past tense, "in the name of." Page 3, line 13. I think the 1, 2, 3, 4, 5, 6 citations, the number is wrong. So from in line 13, it should be changed 250110 to section 25A 102. Line 3, page 15, change section 2501.20 to 25A 103. Page 3, line 17, change 250130 to 25A 104. Page 3, line 19, change 250140 to 25A 105. Page 3, line 21, change 250160 to 25A 202. Page 3, line 22, change 2501.70 to 25A 203. Page 4, line 18, 16 GCA 321, obscene markings does not exist in Title 16 GCA, which relates to vehicles. Page 4, line 20, delete duplicate, section 73-101. Page 10, line 13, 14, when appropriate, GCEC will provide a copy of the complaint to the school administrator/superintendent where the educator is employed. Page 10, line 17, 18, a letter may be sent to the appropriate school administrator and superintendent at the discretion of. DOE has a superintendent, but other schools do not, like charter schools do not have a superintendent, private schools do not have a superintendent, so it has to be administrator/superintendent. Thank you for allowing me to submit this testimony. Merry Christmas.
Ms. Leah, thank you very much for your input. Okay, so we now have Tim Fedenko.
Good afternoon, Senators, and thank you for your time. My name is Tim Fedenko. I am a public school teacher. I also happen to hold the rank of GFT president, so I have to take a little more action than I normally would as a teacher. I come to you before, and I'd like to say thanks. This bill I'm in support of this bill to a degree. However, I humbly ask that you would consider where it says immoral conduct. One of my issues was from the beginning about immoral conduct. You've defined immoral conduct, which I like, right? The current commission's a reasonable bunch of people. They're level-headed, but in the future, it may not be that. And possibly they might think immoral conduct could be homosexuality, could be religion. I don't know. There are other laws, but the issue is that you don't know what's to go down the future, right? Who's going to be in power to revoke certification? I want to protect that in any way. I know it's been said that no allegations, no problems have happened within a year, because I think this board is a pretty reasonable board, but I want to prevent that from happening down the road. All too often, I've seen accusations happen to people and have their lives ruined because of an accusation that was not founded in true. If the teacher loses their certification, the superintendent by law has to dismiss them. We know that the law is changing. I believe Senator Torres and you guys passed something about a quicker, speedier process, right? But sometimes it's a year to 2 years in the Civil Service Commission. That person is without employment, without any money. They lose a lot more than just their career. They have the potential to lose their house and move on. So with that, I would like you to consider that it says immoral conduct, and this conduct behavior includes, and you've listed those, which I think is great. That's exactly what I was looking for. Teachers need to know what is moral, immoral, and they need to follow that. I agree with that. We don't want bad teachers any more than anyone else. But when you say, but is not limited to, it kind of leaves that hanging over there, that he could attack something else that is not listed in this way. All right, that's what one of my only concerns of this bill. And the fact that when things are done through the court system, through the Civil Service Commission, when that action, through the superintendent's discipline, when that action happens and they are terminated, by all means, I think then they should have their certification removed if you're concerned about them running to another state to continue their poor behavior as a teacher or their crimes as a teacher. I'm all for that. But I would ask that you would consider letting it run through the process to make sure that it isn't just a hypothetical situation or an accusation that didn't really happen. If the teacher quit and ran away, then I can still consider that you can take it through the process. If there's a horrible accusation or if molestation took place, that needs to go through the law. Those people need to be prosecuted and put in jail. I agree with that 110%. But I would ask that you consider letting that fall through so accusations don't happen until it's done. It's found guilty. A person is innocent until proven guilty. Thank you, and Merry Christmas and Happy Holidays.
Thank you, Tim. So that's our first group. Do we have any questions for? Thank you for really being very specific with your recommendations. Okay, so we now have. Hang on, I'm confused. What did I do? Yes. Audrey Perez, Roberta Abadai, Mark McCarthy, Dan Del Priori, and Ciferino. Okay, and 3. Ciferino Socaldito. Okay, so we'll start with Audrey.
Good afternoon, Senators. Thank you for this hearing. I come here as not only a certified educator, but as the union chair for teachers, so this bill is important. I want to thank you for introducing amendments to this law, as this is detrimental to our careers as educators. I support the amendments. Just like Tim said, I was very thankful you put all of these things listed down. Specifically, the last section allowing a judicial review of the decisions made by the Guam Commission for Educator Certification. I ask that you address the following points. There are 2. Include language that states these rules shall apply to public educators only after a final adverse action has been taken against a public educator, and the adverse action, procedures, and rights appertaining thereto have been completed, or the time period within which they are to take place or be exercised have expired. I also agree with Tim with the phrase, but not limited to. This phrase is not only vague, but open to interpretation, and I'm scared of what that interpretation may include. I ask that you just consider these in your amendments. Thank you.
Thank you, Audrey. And now we have Roberta Apathy.
Thank you, Speaker Wonpat. Thank you, Senator Underwood and Senator Cruz and the Education Committee members for allowing me the opportunity to provide input to the Guam Commission for Educator Certification Standards of Professional Conduct for Guam Educators, Public Law 32-236, and Bill 209-33. My name is Roberta Abadai. I am a current Guam Department of Education teacher. I am a current Guam Federation of Teacher member, and I am a former Guam Commission for Educator Certification Commissioner. The primary purpose of my submission today is to voice my support for some of the revisions in Bill 209-33 and to raise concerns over other specified suggested revisions. As you know, Public Law 32-236, which was passed on December 17, 2014, deals with standards of professional conduct for Guam educators. Since January 2015, when the law went into effect, concerns have been addressed in the submitted revisions. For example, the revisions include a more explicit definition of commonly accepted moral or ethical standards. When considering revisions, it is important to keep in mind that this law is not just for Government of Guam educators, but all educators who are required or who would like to be certified. This includes private and public school teachers and administrators alike. As a result, we need to be careful of the terminology. The first recommendation I would like to make is to be consistent with the terms used to identify the head of an educational entity. At GDOE, we use the term superintendent, while other educational entities on island use the term director or administrator. Therefore, I recommend that the phrase director/administrator or administrator/superintendent in some form be used to identify the head of all educational entities, specifically administrator-superintendent. And that would be a reference to page 10, lines 14 and 17. I understand the suggestions are being made to the Education Committee to have the law revised to include the Civil Service Commission in the appeals to the licensure and certification process. I feel this is inappropriate since, to my knowledge, there is no other profession in which the Civil Service Commission is involved in the licensure and certification process. From my understanding, under current law, the role of the Civil Service Commission is to hear appeals from disciplinary adverse actions. Therefore, while the Civil Service Commission is involved in adverse actions for employment, it should not be involved in the certification and licensure of educators. Confusing these two distinct procedures could result in most unfortunate consequences. For example, as Senator Cruz and Superintendent Fernandez confirmed at the hearing in February, an adverse action stops when an educator resigns from the position. So if a teacher facing adverse action quits, the adverse action process stops. As a result, the teacher, who may have committed a heinous infraction, would still hold his or her certificate and would be free to apply elsewhere for a teaching position. This is unacceptable. However, if the certification process is kept separate, the GCEC could suspend or revoke the person's certificate if such action is deemed appropriate. This would protect our students and possibly students from other jurisdictions from educators whose behavior falls below the standards expected of all certified educators. If the teacher is unhappy with any action taken by the GCEC, he or she can always appeal the matter to the Superior Court. I asked Attorney William D. Pesh, a practicing attorney at law and a former legal counsel for GDOE, if there are any Guam professionals that require revocation of licenses or certificates to be reviewed by the Civil Service Commission. His letter is attached as part of my evidence packet. His review of Guam statutes found that the Civil Service Commission is not mentioned in any of the licensing and certification procedures for the following professionals: physicians, nurses, dentists, optometrists, pharmacists, allied health, and attorneys. GCEC is the agency responsible for certifying educators, not hiring and firing them. As such, decisions made by GCEC concerning certification should not go through the Civil Service Commission for review. Rather, like all other professions, educators who disagree with certification action taken by GCEC should appeal directly to the Superior Court. The Administrative Adjudication Law, subsection 9239 states, "A decision of an agency which is in accordance with law and supported by substantial evidence shall be conclusive." In addition, subsection 9240 states, "Judicial review may be had of any agency decision by any party affected adversely by it. If the agency decision is not in accordance with the law or not supported by substantial evidence, the court shall order the agency to take action according to law or the evidence." Attorney Pesh confirmed the finding that the Civil Service Commission plays no part in the certification and licensing process for these professions. Therefore, I support GCEC's affirmation that the Civil Service Commission should play no part in the certification and licensing of educators. Concerns continue to be raised that certification will be revoked if an educator is seen holding a beer, wearing a swimsuit, or talking too loudly. As a careful reading of the current law reveals, these behaviors are not identified in any part of the public law. It is interesting to note that in the public hearing, predictions were made that there would be a flood of complaints made against educators. Despite these dire predictions, over the past year, not one complaint has been filed with the GCEC against any educator, teacher, or administrator. It is quite evident that GCEC has no intention to police the personal life of the educators. GCC is not going to seek out complaints, but will be there to provide an avenue for complaints filed by concerned individuals to be heard. Over the last 6 years, the Guam Commission for Educator Certification has worked with the stakeholders to revise educator certification requirements. It is expected that in the future, revisions will continue to be made to the standards of professional conduct for Guam educators. I ask the senators to support the proposed revisions in Bill 209-33 and not to seek the inclusion of the civil service in the licensing and certification of Guam educators. The certification standards of professional conduct for Guam educators, Public Law 32-236, was approved to protect the students from experiencing unethical behavior and the people they trust with their lives. Thank you.
Thank you, Roberta. Okay, we now have Mark McCarthy.
Thank you, Senators. My name is Mark McCarthy. I'm a teacher with the Guam Department of Education. I've been a teacher here on island for 25 years. I have 2 children that are currently in school right now, and in public school right now, and I'd like to tell you that I'm testifying in favor today of these amendments. I am in favor of it. I do have one concern, and that is with the phrase of "but not limited to." Mr. Fedenko pretty much covered all of the points that I was considering as well. I like the fact that you are defining what is moral and what would be considered immoral behavior. And most of the teachers I've spoken with that I work with are also in favor of this. They like the language. But when we leave the definition of morality open to something that is not specified, that can change from time to time and from person to person. As Mr. Fedenko said, or refer to the current commission members are pretty sound, reasonable individuals. They have wisdom, they have compassion, they have a lot of knowledge, but that may not always be the case. There was some recent media information regarding some other commissions and other boards where we're having a difficult time appointing people to fill in these positions and work on these boards. That may happen someday with the Guam Certification Commission as well. And we may get individuals whose definitions of morality are very loose or very strict, more so than the average community member. So that is one thing I would like you to consider as you go through this process. Thank you very much.
Thank you, Mark.
There we go. Thank you. Madam Chairman, Senators, as a field representative, a parent, and an educator, I also support the proposed amendments, particularly that allowing for judicial review. In regard to the comment concerning allowing the Civil Service Commission and the rights there appertaining thereto to proceed first, normally one would not expect the Commission to consider suspension or revocation unless some allegation of wrongdoing has taken place. And what has been suggested by the Guam Federation of Teachers pertains to classified employees only. Those educators that are in the private sector are not protected by the merit system, nor do they have the classified rights and privileges of having adverse actions instituted against them and proceed through the system. It's standard operating procedure that if an allegation of certain improprieties are made against a teacher, they're removed from the classroom and assigned to the head office or the warehouse or another place where they would not have contact during the time of the investigation. The investigation, the adverse action procedures must be completed within 60 days under Guam's code, or it cannot take place. So that would not involve much time for the Commission to allow that procedure to take place. Also, it was alluded to, I think, by the written testimony of Gail Hendricks that the Civil Service Commission is scheduling cases in 2017, which is correct, except that Public Law 33-81, sponsored by Senator Torres and Senator Cruz, sets standards by which the Civil Service Commission must complete adverse actions dealing with termination in 4 months from the date of the appeal, or 6 months if it's other than a termination. That law begins to take effect December 31st this year, 2015. So at the most, if you're dealing with a termination adverse action, you're looking at basically a 6-month period to go through the process. It is not suggested that the Commission could not open a file and red flag it, that if a teacher did something wrong and resigned and left, the Commission could not institute its own action at that time. What the GFT is concerned about is having a dual investigative and sanctioning apparatus going against the teacher, educator, because it could be an administrator also, who's alleged to have done something wrong. So that this particular educator has to confront both the adverse action and civil service cases as well as the Commission cases. All that is asked with the proposed amendment is that the Commission not begin taking its investigative and prosecutorial action for alleged wrongdoing until the adverse action and civil service provisions for classified Gov Guam employees, which are created in the Organic Act of Guam as rights and privileges, are exhausted or waived or not executed or not utilized. Then the Commission would commence to take any action. But it would not be a situation that someone could just leave the island, because if they did, then their any subsequent employer would normally ask the commission, what do you have? And the file would then reveal that. All we're asking is to respect the rights and privileges of educators under the classified system at that point in time. And we do, on behalf of GFT, appreciate Senator Wanpat's staff meeting and discussing the GFT concerns, as well as that of Senator Underwood and Senator herself, as we work together to try and create a good and workable law that protects the public, the students, and the educators themselves. Thank you.
Thank you, Dan. We have Ciferino.
Cifaldito. Yes. Good evening, Senators. I'm a teacher here in the Guam education system. I am here today as a concerned GFT member and a certified educator. I thank this committee for introducing amendments to Public Law 32-236, as this is detrimental to our career as an educator. I support the amendments, especially the last section allowing judicial review of the decisions made by the Guam Commission for Education Certification. However, I ask that you address the following points as well. Include language stating these rules shall apply to public educators only after a final adverse action has been taken against a public educator, and the adverse action procedures and rights appertaining thereto have been completed, or the time period within which they are to take place or be exercised have expired. Second, eliminate the all-inclusive phrase, but not limited, in the law, especially in sections 3.09, which refers to immoral conduct. With this additional language, the careers of thousands of Guam educators in our public schools will not be endangered in the event of mistaken actions. So please consider these in your amendments, and I would appreciate it if you reconsider my testimony on regards to this. Thank you, and Merry Christmas.
Good afternoon. State your name and make sure that that's on. The red light is on.
Good afternoon, Senator. My name is Helen Isapeta. I am a Chamorro teacher, was at Finagayan, and now I'm at JQ San Miguel. I was released of my duty at Finagayan without no notice. I was given a post-it to start that school Monday. This is from the principal of Finagayan, Ms. Raylene A. Renan. I've been teaching at Finagayan for the last 25 years, and I had a classroom with a bathroom, and she removed me from that classroom and put me in room 315 with no bathroom. I'm an employee with disability, and I fell at a school twice. That's why I'm wearing a cane. I was not offered demotion. I was offered suspension, and then I was offered to leave. I feel that Mrs. Renan had harassed me since last year when she got to our school, because in the handicap parking, I had a parking until she took it away. She tried to spray it, but it didn't cover it, so she has to park at the other side. I've been harassed by her many, many times since last year, and now she transferred me to JQ San Miguel involuntary transfer. One. She also, I'm a seniority there, and I'm a person with disability. I love my student, I miss my student. But on November 20, in the middle of my class, she told the AA that she want to see me right there. So I told the AA, Ms. Vanzi Paris, that I cannot leave my student because I have a responsibility of 29 students. I'm not just going to get up and walk. So after I released my kids, my student, I went to see her. She gave me post-its telling me to report to JQ Monday morning with no document. That's one. The other one is she's supposed to be my mentor, helping me. But instead, she's trying to remove me. Yes, you know, I'm a very good teacher. I love teaching the language. I find my student, if they cannot pass the test, the written test, I have a project to follow that. And that's how I grade my kids. I also have disability students, which I work with them. Because I know that, you know, they're here for a reason. God sent them for a reason. And I work with them because I love them. I know how to work with students with disability. On September, she sent two of the Chamorro teachers for training on the artistic. And she did not inform me that I'm going to cover a class. I have 55 students in my small classroom. She was there, she saw it. She didn't give me any input on that. I don't know. But like I said, I was not offered demotion. I was offered to be let go. I signed up for class last year, but due to my illness, I didn't go to class, but I did sign up for this fall to take Pacific Culture. I'm lacking 1 credit. That's all I'm lacking. And I told her that in order for me, can I become an on-call sub and can I work and finish my school this year? She told me she didn't want me in the school. I told her to go to school and take anger management and professional growth. You know, I'm a very patient teacher and I love teaching the cultural. I speak 4 languages, but I love teaching the cultural. Oh, she's been doing this to a lot of teachers, but I'm not talking about a lot. I'm talking about myself. This is the last straw. And I know I call you, and I call you for help, because she has been harassing me for almost 2 years. Now, all of a sudden, when Mrs. Iglesias was there, Vanji, I never was sick. Now when Mrs. Ronan is there, I'm sick. So, I need answer, please, because I don't know.
So I thank you, Ms. Cepeda, for taking the time to come down here. I believe that what you are testifying on is actually personnel matters and there are procedures in place if you need to go through the grievance procedure and you have been treated, that can be explained to you by the superintendent or even personnel or the EEO, the EMRO. But, thank you for sharing that. But at this point, I believe that that's an issue that would need to be addressed first by going through the
procedure, which I did. I went to the EEO, and I went through all those things. I came here to testify, so
Okay.
you know
So noted.
what the administrator is doing to us
Okay.
teacher.
Okay, so noted, Ms. Cepeda. And the superintendent is here, so, okay.
I did talk
And
to
he
you.
heard that. And you put it on the record.
Okay,
Thank you, Ms. Cepeda.
thank you. Thank you both.
I believe we also have Patrick B. Kidugwa. Yes, please come up. Please state your name and make sure that
Yes,
the
ma'am.
microphone.
Okay.
Thank you.
Yes, I'm Patrick Bello Kidagwa. I'm an educator at George Washington High School. I'm also Guam Federation of Teachers steward. And I also have a master's degree in special education and been teaching for going about almost 19 years. I'm supporting the bill that we have here, the Public Law 236. Some of the things that, of course, some of my colleagues I was already informed that they pretty much reiterated some of the things that were noted that you've already known already. I'd also like to also say the same thing. Some of the language is somewhat vague, and we'd like to maybe clarify some of the things that are in the amendments. I think you're very aware of that. These rules shall apply to public education only after a final adverse action. I think you guys already noted that. Is that correct, ma'am? Okay. So pretty much I agree with my colleagues. I just came here just to reinforce what they said. There's no need to reiterate that. But my experience so far is just fresh out of the boat, GFT, a steward. I've just been doing it for about a year. And I'm like learning on the job. And what I see is that my experience is really not about policy issues. A lot of it is, and I'm just hearing some of this testimony, just a tidbit of this. There's some issues with how some of the leadership in the upper echelons, like administration, where, and I'm not accusing anybody of that, but I've seen in my own experience a lot of abuse of authority. And this abuse of authority could get really personal in some matters instead of stay professional. And that's where a lot of people get hurt. And I believe this law, although it's good, there also could be potential where it could be used against some of the employees, where a lot of the vagueness and the things that are in a gray area could be pretty much trumped against someone for personal reasons. I have to say that my experience for about a year and a half already, a lot of the issues that I've been dealing with, both on the administrative side and the employee side as a steward. And again, I want to say that I always let my administration know that I take things very seriously in terms of being very fair and equitable on both sides. So I'm not just there for the person I represent as a steward, but I'm also there on the side as well as the administrators and trying to find out how can we come to a very amicable position in the middle to where we don't have to take anything further up on the level. But what I found in a lot of times is there's an issue of pride. And this pride comes from the upper echelons where they're so used to having a lot of power. And with this power, instead of helping people up, they break them down hard. And if they got personal issues, boy, they want to crush them. And I've seen that. And of course we have, as you said, ma'am, about the protocol with the procedures and so forth that need to be followed. But in the interim, there's a lot of unnecessary suffering going along with some of these people that have been in these cases. So, with that being said, one of the things that some of the ideas I might have, and I might go to UOG, my alumni, is probably talk to some of the professors about maybe getting a class and conducting that before someone takes their master's in, how would I say, education leadership, and include things that do with ethical, how do you say, learning things about how to take your authority and your power not to hurt people and so forth. Those kind of courses to be added to that. Because, you know, when you have a position such as a principal, yeah, there are a lot of stress and pressures. But you have to understand that you're there as a servant leader. And I've seen it to where they take this where, you know, they just go around with an iron fist. And now you put something in place like this that the servant, the concerns that we have, and if they're not being considered, there's going to be a lot of potential for people to be put in a position of injustice. So with that being said, ma'am, that's pretty much what I'd like to say, and I would like to thank you for this opportunity to speak my voice on behalf of my colleagues and of GFT and the members on the island. Thank you. Right.
Thank you very much, Mr. Kidaba, for taking the time to come down and sharing your thoughts. Do we have anyone else who would like to testify? Okay, Madam Speaker, is there anything you would like to say?
Thank you very much. Just like to say that I really appreciate everyone coming out. And Dan, you're right, thank you very much also for working very closely with my staff and with Senator Underwood. There's been a lot of back and forth, and also working very closely. I thank the commission members as well for your due diligence and really working. And I know that a lot of it was to try to categorize, like you say, especially the part of the immoral turpitude, the definition, and actually kind of putting all the laws together basically in one page that has been in existence for many years, but more importantly, how then the different definitions by law basically provides, and expands on the definition. So, and we appreciate, of course, the detail in terms of some of the amendments, technical amendments, and other amendments for consideration. So, of course, the superintendent had asked me earlier too, he said to allow for the committee to continue to keep it in committee until then we make all the changes that were being recommended, and then again continue again the dialogue again to have you review them even before then it's going to be reported out of committee. So we'd like to give everybody that opportunity to keep it open, to send any testimonies in, any written testimonies. Thank you.
Thank you, Madam Speaker. Vice Speaker? Okay. Well, everyone, I do want to thank you too for taking the time to thoroughly go through the proposed amendments. And, we all know, we all genuinely care. We care about our students, but we equally care about our educators. And so, to the extent that really there has been a lot of work that just reflects the professionalism and the high standards that we all expect of each other, right? What I detected from this is that there's still a major issue that has yet to be resolved. I believe that there needs to be some more conversations that we probably just need to have before we actually send this bill out of committee. And I'll be in discussion about that big issue with Speaker Wonpat, and then maybe we can all come together again. But having said that, of course, it's just complex. Why? Because we're all human beings. We just all are very different, and we tend to get into interpersonal conflicts. And so just as we are very concerned that all it is that one child that may be subject to abuse, we are equally concerned for one educator to be falsely accused, right? Because that would then undermine the public trust as a whole. And I think what we want here, all of us want, is for our students to be safe, and for our educators likewise to feel that they have the confidence of the community. So with that, I just want to thank you again and for your presence and the work that you put in with the public testimony that you provided this afternoon. We will continue to accept testimony, Madam Speaker. Yes, and it can be sent to my office. And the public hearing is now adjourned, and we'll continue to accept it until January. Okay, thank you very much. It is now